Welcome to today's webinar in the ConMA-CL-Carry 2023 MSHA webinar series, the MSHA jurisdiction. Where does MSHA's jurisdiction and authority begin and OSHA's end? That will be the topics for our discussion today and what we'll be looking at throughout the course of our webinar. So it will be taking a look at a number of different areas, both from the Mine Act, the OSH Act, the interagency agreement between the two, as well as some case law that we've seen come out in the last few years, and some as recently as last month that talks to this question. As always, I am Nick Scala, your host for today, the chair of the ConMA-CL-Carry MSHA Workplace Safety Practice Group, where I represent mine operators all over the country in all aspects of dealing with MSHA, whether that is contesting citations, or helping in an investigation management with injury investigations or agent investigations or discrimination investigations, or in many cases, discussing and reviewing jurisdiction for small operations, new operations, and just kind of trying to hammer out some of the areas of ambiguity in this section of our workplace. It is an area where there's a lot of questions. Some of the answers are pretty cut and dry. A lot of us know that our operations are going to either be MSHA regulated or OSHA regulated. There's not a lot of question in there. Sometimes where this question of jurisdiction comes up, it has to do with what's taking place with our contractors who are on site, and we'll talk about that today, as well as what training or what requirements are contractors required to have when they're working on our site. In most instances, we know whether or not we're under a jurisdiction of one of the different agencies, and those where our questions lie. In terms of kind of other parts of it, though, it's not as clear. And so this is going to take some time today to focus more on those not as clear areas. We'll talk about contractors later this year on jurisdiction. We'll pay a good bit of attention and drill down really on the training requirements there, and we'll mention it here today. But this is going to be looking at kind of those gray areas, right, where we aren't entirely sure where our jurisdiction might be, what questions we need to be thinking about, what questions we need to be asking. And then, we'll talk at the end about what we do if we think we're in a situation where our jurisdiction is not clear. So talking about determining the jurisdiction, let's start with the basics, right? What always do we have to go back to when we're talking about anything related to MSHA and or OSHA? Are the acts that started them. So the Mine Act here, for our purposes today, is going to be kind of home base. And really after that, the interagency agreement that we'll talk about starting on the next slide. But what does the Mine Act say? It says that each coal or other mine, the products of which enter commerce and the operations or products of which affect commerce, and each operator of such mine shall be subject to the provisions of this act. Okay, that is a relatively short sentence, but a very much all-encompassing one for operations under the mining industry. And we have kind of that coal or other mine language. I know sometimes people are confused why that's the case, and that's because the Mine Act of 1977 is largely based off the Coal Mine Safety Act, and they modify the language for coverage. So that's why or other mine is kind of the term there. And that really means, though, kind of a broad coverage of land from which minerals are extracted, above ground or underground, private ways or roads are pertinent to such areas, or the land, excavations, workings, and structures, facilities, equipment, tools on the property, including or to be used in or resulting from the work of extracting such minerals from their natural deposits, or to be used in the milling or preparation of coal or other materials. So this isn't just extraction. It's also initial processing, and that is usually where we see some of this confusion take place, especially for kind of small operations or portable operations, and where the discussion of the borrow pit usually comes into play as well, which we'll discuss today. So we start off, MSHA has a lot of authority. They get a great deal of range of what is going to fall under their authority and their jurisdiction when it comes to mining or extraction of materials, but it is not open-ended. There's some limitations to it, and there's limitations to it because OSHA already existed at this point in time, and so we had an agency that had authority over all working conditions of employees engaged in business affecting commerce. That's in paragraph 2 on the screen right now. But it says, except those conditions with respect to which other federal agencies exercise statutory authority to prescribe or enforce regulations affecting occupational safety and health. So that is the carve out right there from the OSHA Act that pushes that authority over to MSHA to regulate the mining industry. This is the beginning of the interagency agreement between MSHA and OSHA. This is really, if the Mine Act and the OSHA Act are home base, this is first base when we're trying to evaluate a question of jurisdiction between the two agencies. And this is a document that was published in 1979, right? So a couple years after the Mine Act and MSHA came into existence, which talks about the delineation of authority between the two agencies and how they're going to interact and kind of play together when regulating safety and health at the nation's workplaces. So what we see, though, is they've kind of broadly broken it out in the beginning, right? MSHA talked about the Federal Mine Safety and Health Act of 1977. It authorizes Secretary of Labor to promulgate and enforce safety and health standards regarding working conditions of employees engaged in underground and surface mineral extraction, related operations, and preparation and milling of the minerals extracted. So it isn't just extraction. It is that initial preparation, it is that initial milling, is the term that we'll see used a lot. It's also kind of the support and on-site operations that go into it. So if we're talking about, dedicated mine-specific facilities which are used to help further the mining process, they're likely going to be considered as part of the MSHA jurisdiction. That's, starting to get into that gray area, but for the most part, we have that understanding. The question comes about really, what is related operations? What is the extent of preparation and milling? And those are typically the areas where we get the questions. And even when we're talking about borrow pits, which there's extraction involved there, the question is the related operation and are we engaged in milling or preparation of the materials? So, in addition to kind of having these broad strokes, we also get some pretty pointed and specific operations in the Memorandum of Understanding that, carve out some very specific items that either fall under MSHA jurisdiction or OSHA jurisdiction. And one area we see that is in paragraph 6A and B of the interagency agreement, where we start talking about where there is distinctive jurisdictional determinations back in 1979, right? I will say they, as you would expect the agencies to do, give themselves a good bit of deference here to say, well, we can, agree that different areas are covered by OSHA when they might traditionally be covered by MSHA, or vice versa, because it is more convenient to the agencies, or we think one might be better positioned in order to enforce regulation there. So there is some moving parts, but for the most part, these items fall under MSHA jurisdiction in paragraph A and OSHA jurisdiction in paragraph B. And we'll talk about these a little bit as we go, because both the jurisdiction as well as the location and the function of the operation help kind of determine where those gray areas are going to fall. But we can see in here, MSHAs, it includes salt processing facilities on mine property, stone cutting and sawing operations on mine property, with, again, another carve out, and then alumina and cement plants. Those are kind of distinct areas where we know we're going to find a MSHA, unless there's kind of extenuating circumstances there about where they're located or co-located. OSHA includes, ceramic plants, fertilizer plants. We're going to see some of the caveats here. Concrete or asphalt batch plants, that is a one where co-located or not, OSHA has jurisdiction over those. Even if they're 100 feet from the mining operations, those are ones where we're going to see MSHA jurisdiction or fall off and OSHA be assigned. It also includes salt and cement distribution terminals that are not located on mine property. Again, that co-location question coming into play. If they're co-located on the same property, then MSHA has jurisdiction. And then milling operations associated with gypsum board plants when, again, not located on mine property. So there's a couple carve outs here that really boil down into those areas of whether or not we have co-located operations and where these divisions start to be made. And then that really is usually the basis for the questions of, well, how far is separated enough? What does appurtenant mean? What is adjacent? What is close enough that we are going to try and consider them the same way, or maybe an OSHA or an MSHA inspector does, and then we're in the discussion of challenging a jurisdictional question. Okay, all right, so we got a question that came in. I think we'll probably table this one because this is a question, but it is, when do you recommend we notify MSHA and obtain new MSHA legal ID on greenfield sites? The questioner notes that different MSHA districts have notified me differently. One says as soon as we break ground, the other says when we start processing material. So we'll talk about that a bit later, and I'll probably reach out to the questioner directly too, because this is certainly an area where we don't get enough certainty from MSHA, and we see a lot of difference between the districts. It's probably somewhere in the middle of the processing material and breaking ground, and we'll touch on that in a bit as well. So going back though to this basics, what is going to be covered by MSHA? These are the operations that are listed, right? So mining operations, whether that's underground, open pit, quarrying, dredging, kinds of these things that we specifically know to be mining, right? The extraction process. But on the right side, we got an even longer list. And this is what MSHA considers, or the agencies consider, milling. And they have determined that milling is part of the processes that are under MSHA. And some of these things are not used regularly at operations, right? Retorting, leaching, briquetting, heat expansion, calcining. Other ones, though, are pretty much always used in any kind of normal mining operation. So crushing, sizing, washing, those are pretty basic elements. And that is an area where we often find, a borrow pit immediately get excluded. Are you essentially making big rocks out of small rocks and separating them by size? Then you're engaged in processes that are assigned to MSHA. It's really can sometimes be as basic as looking at that, even though you're not. Maybe you're using it internally. Maybe it's an intermittent use. Maybe it is, just pulling out material, and you're only sizing it to, decide what might be better used at this part of the project or the ladder. You're going to have to explain that if you're getting called into question that you're engaged in mining activities, because all we're allowed to do that is outside milling for the borrow pit operations is essentially extract and then pull out the scalping screen and run it through with removing, debris and trees and trash and things like that. Otherwise, we have to use, these processes. And then also sometimes, we see processes here, and we're going to talk about this a bit later, where we're very much seem like we are towing the line of manufacturing when we're talking about kiln treatment or leaching or even drying and roasting. We'll talk about a case here in a few slides that OSHA claimed jurisdiction over a part of an operation that was historically MSHA because they were drying materials, and it was determined that that was manufacturing and not milling. So the questions are there, they remain, and this list, though, I think it's more inclusive than sometimes people think that MSHA covers. And in every one of these cases on jurisdiction, pretty much every single one of them, we go back to the question of, is milling occurring? Because the extraction question, that's more straightforward, right? It's this processing and milling. Where does that end? And where does our process leave milling and turn into manufacturing? So, we have some, though, where these activities are specifically listed as under MSHA jurisdiction. So if we're going to be having these take place at our site, we have to consider that that's where we're starting. And if we don't think we're an MSHA jurisdiction facility, we have to begin to figure out why our use of evaporating is different than it would be considered in a mining facility. Now, there's a lot of data here. This is pages long. Each one of these has its own distinct definition attached to it. I obviously didn't post those up here. It'd just be an overwhelming amount of information for us to read through. But this interagency agreement contains a lot of specifics in it. It's not a perfect document by any means, but it usually helps us get on track. If you have a question of jurisdiction, we want to start there. We are likely going to understand if we're, again, going to fall under the Mine Act or the OSH Act. But, if we have questions about the gray areas, that's where we want to start. And frankly, if MSHA is coming out and claiming that your operation falls under their jurisdiction, or vice versa with OSHA, having some familiarity with that document, it allows you to speak from a position of knowledge as well as a position of authority, because sometimes all the inspectors don't know it. Frankly, I was talking to someone who is a bit higher than the inspector level in MSHA recently on a jurisdiction question, and I mentioned this interagency agreement to that individual, and they were unaware of it, which I'm not sure, how that could be the case if you were actually, in a position to be discussing whether or not operations fall under jurisdiction. But nonetheless, it does happen. So be familiar with it, be prepared for it. If you have questions about what's going to be taking place and whether or not it falls under it, come back and look here. And if you're still in a gray area, that's when you got to dig a bit deeper. We talked about this a bit ago, but there are specific areas that are called out as going to OSHA and under OSHA jurisdiction. In this, we see kind of a list of different facilities, but it's not that clear, right? We talked about, there's gray areas, and they give themselves these gray areas because they talk about different classifications that make these, whether they're OSHA or MSHA. And, this is what we come down to see, right? So, the gypsum board plant, we talked about it. If the plant is located on mine property, OSHA jurisdiction commences when milling is as defined is completed and the gypsum and other materials are combined to enter the sequential process necessary to produce a gypsum board. If it is not located on mine property, OSHA has jurisdiction over the entire plant, right? That is a question that has to be evaluated. And We also, though, get inspectors who, say that they want to go and they want to look at the milling part of plants that aren't on site because they know they're 20 miles away or 10 miles away. And we have to push back at that point, right? We don't want to let that creep happen necessarily. So, know these kinds of distinctions. With brick, clay, pipe, and refractory plants, OSHA jurisdiction commences after arrival of raw materials at the plant stockpile. So MSHA has jurisdiction until they get to the stockpile over those materials, right? Or, with asphalt mixing, again, it commences after arrival of sand and gravel or aggregates at the plant stockpile. If we have co-located, right, if we have co-located asphalt or ready mix plants on our mine sites, then, obviously we're going to have separate stockpiles, or if we don't, we need to have separate stockpiles because that is a distinction in jurisdiction. If you have equipment that's going back and forth between co-located facilities or personnel that's going between co-located facilities and working at both, those people are going to fall under the jurisdiction of both agencies. So, or that equipment, I should say. So it has to comply with the regulations or the training for each. And that's something that, we have to evaluate and determine if we want to have dedicated equipment or dedicated persons at, an asphalt mixing plant or a ready mix plant, because we don't want them crossing over and being on the MSHA side or vice versa. So, we need to think about how that's going to work with the co-location, because that's really an area where we want to have at least a clear area where our lines of jurisdiction are divided, right? MSHA should never show up and be climbing on your batch plant. That just shouldn't happen. OSHA should not show up to inspect the batch plant and go start climbing on your crusher or your screen decks because they're a couple 100 feet away and they want to check them out, right? We need to keep those lines clear. So know where your jurisdiction begins and ends. The clearer we can make that line, the better. The asphalt and the ready mix plants, those are pretty cut and dry basic elements, right? We don't usually see inspectors from either of their agency trying to really expand or grasp onto those, but usually where there are questions or there are issues, it's with the kind of sharing of materials or equipment or personnel, and not having, that be succinct and be properly trained or maintained in the process there. So, we want to look at it from that standpoint. We also want to look, again, where do these lines end? Refining, I added at the bottom there, it commences at the point when milling is completed and material enters a sequential process to produce a product of higher purity. That's a confusing statement, right? That when does that happen? Because we can see that the process of milling, it includes a number of different activities that can take place in the refining process, like calcining or evaporating, leaching. Those are often activities that happen in the refining process as well. So where do we see milling and be completed, and we see it enter that sequential process where, again, MSHA's authority to inspect ends and OSHA's begins. So when we have these kinds of processes, whether we're bringing material in or we're doing it all on site, we need to be evaluating this so that we can determine where we need to assert those claims of jurisdiction have changed. So, looking at that language, we can look at MSHA guidance or OSHA guidance. Sometimes it's not particularly helpful because it keeps giving itself kind of that cyclical or circular argument that it depends on this definition, or it depends on this definition, or it depends on this deference, or when did milling or manufacturing begin or end. And so really that comes down to evaluation of cases. I bring up a couple just for the purpose of discussing it. These aren't recent cases necessarily. The Kaiser Aluminum case is actually quite old, but still a good case when determining the process of how we were seeing this kind of review take place, and also some other lessons to take from it. And then Cranesville aggregates, because that is more recent, and I think is a unique case in that, we don't often see OSHA claiming areas that are historically under MSHA jurisdiction, and that's what happened in Cranesville. So we'll take a quick stop and just look at the Kaiser case first. And so this was a question of jurisdiction. It was following a significant explosion at the facility, and the question was brought forward along with a number of other questions about where did this process of processing or milling or refining bauxite concentrate take place, and what was it under, right? And so this facility, it got bauxite concentrate shipped in from, I believe it was Jamaica. They used that to complete the bear process, is what it was called, to turn that into aluminum oxide or alumina, and then that was sold for smelting or manufacturing into derivative products. So the company argued that they should be covered under OSHA because this was refining instead of milling. And eventually what the Fifth Circuit decided was, in affirming lower rulings, that the process constituted milling, and it was not yet refining. And that had to do with a number of factors, but for the refining process and whether or not we were in milling or refining, it came down to whether or not this material that was being shipped into the Kaiser plant could be used by other end users in a similar way to create derivative products, or if it was only in use for someone who could perform this bare process and then create something that end users could take and manipulate further. And that's essentially what it came down to. It looked at, was this bauxite concentrate that was being delivered usable by anyone else, or only a facility that could turn it into aluminum oxide or alumina. And because it was a situation where it had to undergo this further processing before it could be refined further into a subsequent or derivative product, or as we see in the jurisdiction here, a sequential process to produce a product of higher purity, it was found that the facility was under MSHA jurisdiction. And it's interesting to read and look at this because it does look pretty closely at the distinction between milling and refining, but also gives us some good lessons in terms of just challenging jurisdiction in general, because the plant had been under MSHA jurisdiction for years, and had received citations and had paid citations and operated without challenging jurisdiction. And all these arguments go against you, all right? So if you are in a situation where you don't think you should be receiving inspections or enforcement from OSHA or from MSHA, you cannot sit back and wait until it's a convenient argument to say that they don't have jurisdiction, so you want to contest it. Each time you accept them coming on site and accept them issuing a citation, you are, accepting their jurisdiction over your facility, and it gets harder to challenge it. And it's seen as a significant factor in upholding jurisdiction. So if, you get an inspection from an MSHA inspector, or they're trying to go to an area where you don't believe they should be, you have to push back immediately. You cannot say, well, it's a $145 citation, I'm just going to pay and move on, because you are at that point now acquiescing to their assertion, essentially. And they will use that against you in any challenges, in any litigation. It is just the way that it will be. So you got to consider that in your litigation strategies, and how hard you push back and how quickly you push back and in what way. Kind of somewhat similarly, in terms of is it milling or manufacturing. The Cranesville case is interesting because this was kind of on the other end of this, a historical MSHA site. It was a mine. The mine had a number of different facilities on it that facilitated the mining process or what they were trying to do there. And one of those was a bag plant. At the bag plant, the company dried material, sand, and then bagged it or added other components and bagged that sand for sale or use by end users, right? So they'd always been under MSHA jurisdiction. Well, there was a complaint made to OSHA. OSHA came in and OSHA issued a number of citations, more than $450,000 in citations to the bag plant facility. And in that, the company did push back and said that, you know, this is an MSHA facility, you got to vacate all these citations. And the Occupational Safety and Health Review Commission did that on appeal, and the Second Circuit on appeal ruled in OSHA's favor and said that they could consider this a manufacturing process and under OSHA's jurisdiction. So at this facility that was historically MSHA regulated and at a mine, on a mine site, there is now a bag plant building. That part of the building is under OSHA's jurisdiction. And in that, it was because the argument was made by OSHA that the sand was essentially stockpiled outside the bag plant. Some of that sand in that form from the stockpile was sold to customers. Some of that sand was also put into the bag plant to be dried, bagged, or had additional components and materials added to it and dried and bagged and sold as different product forms. And so the OSHA argument in this situation was the milling ended at that stockpile, like we saw with some of the distinctions from the list of companies, or I'm sorry, the list of industries that fall under OSHA jurisdiction. You know, it happens at the stockpile. That's where it ends. And that's because the argument is your milling has ended at the stockpile. It is now ready to be sold and used by end users along for you to further manipulate it and create something. But that further manipulation is manufacturing. Obviously, Cranesville pushed back on a number of reasons, both historically under MSHA jurisdiction, as well as, you know, we're drying processes that are you know, drying is taking place here. That is specifically listed under milling. You know, yet the court still deferred to OSHA and their interpretation that this was the manufacturing process beginning at that stockpile, and anything that was taking place in that bag plant was manufacturing and not milling. So an interesting kind of distinction in two cases where, you know, the question is, where does milling begin and end? And we talked about that. That's a question throughout. And in this one, you know, we have the circumstance where OSHA was claiming jurisdiction over a historical location that was inspected by MSHA and regulated by MSHA. In the other one in Kaiser, it was a historical MSHA site that was now trying to say we're refining and we're regulated by OSHA and should be moving forward. Both of which, you know, the aim was obviously to have enforcement withdrawn and the regulations that apply to the site changed. But, you know, in two different instances, one, we have the Secretary of Labor and OSHA pursuing this change in Cranesville, and the other one, we have the operator. So things that show that, you know, came out in 1977, the Mine Act. This MOU, Memorandum of Understanding, came out in 1979. We're still having questions about what is milling. And I think we're going to continue to, and we're going to see those pop up in the refining space. And, you know, how that's going to kind of continue to evolve. But we need to kind of, one, take from this, we can't sit back on our challenges. And two, we have to look at it from the fact that sometimes the agencies are taking a stand because, you know, they want to creep, they want to expand. Sometimes they're taking a stand for other reasons. In this case, I think probably a big part of the Cranesville case is that they issued $450,000 in penalties. You know, and that's probably a big part of why they took that litigation forward, although they had agreed to a settlement before the ruling came out. In the case that it was found to be OSHA's jurisdiction, reducing that penalty packet significantly. But still, you know, I think that's probably one of the reasons why this was a historical area. There was a complaint that came in, OSHA found that they found violations and they issued them and then defended them. So again, try to avoid the point where we even get to that. If we have OSHA coming on site and wanting to inspect our mine, in an area that has historically been regulated by MSHA, and we're not seeking OSHA to take jurisdiction of it, we want to obviously fight at that point in time and, you know, try and prevent that inspection from taking place. Because if you're asserting jurisdiction before you're letting them there, they do the inspection, you know, perhaps it could be avoided or maybe not, but you are going to put on the record at that point in time your stance on it. I'm just seeing a question that came in now. So this is a question that is somewhat unique. It says that our quarry is in a very remote in Alaska. During a MSHA stand down talk, an inspector said we were violating a standard for berms and guardrails on an access road. This road is partially owned by our company, but also goes through Forest Service land that we do not have permits to access. Does MSHA have jurisdiction on the portions of the road we don't own to enforce this standard? So that is a very good question. And as you'll probably hear me say, with most questions that come in on jurisdiction, it's not entirely black or white. A lot of it comes down to, you know, your ability and your use of the road and your ability to change or access it. If you don't have permission to access that roadway through the Forest Service land, and you don't access it for your operations, I'm not sure why MSHA would want you on it to berm it or could hold you to that. If we do utilize the road, but we don't think we have the ability to put berms up, I think that's a much more nuanced question that we would have to look at what kind of control we have over it, and what kind of authority we have to change it, and working with the Forest Service department there. But if we aren't using it and we don't have permits to access it, I don't know why MSHA would try and require us to put berms up on it. But I would be happy to talk through that more and get a bit more detail from you at the close. Somewhat similar to the question that we just had is a recent case. It's actually still on review before the DC Court of Appeals, and it is called KC Transport. And so in this case, we have a commission decision. It was a split decision from the Federal Mine Safety and Health Review Commission, where 2 to 1. There's only 3 commissioners at that time. And the question is whether or not MSHA has jurisdiction over contractor haul trucks that are used at coal mines or other customer locations when they were parked at a contractor repair facility, not on the mine property, but connected to the mines by haul roads. So a bit of a question on, you know, where are we located with respect to a mine and what are we doing at that location? You guys might recall a decision from a few years back, or were you talking about it on other webinars, called Maxim Rebuild, where the Sixth Circuit took up just this question and issued a ruling that was, you know, frankly pretty good for the industry in terms of curtailing what at that time was MSHA's continued efforts to expand, right? To expand their grasp. I want to go to this shop. I want to go to this offsite maintenance facility because, you know, you're repairing mine equipment there. And, you know, that was a concern for a while, continues to be. We need to monitor that. But in that maximum rebuild decision, it was a pretty strong decision saying, unless a facility is on or adjacent to a mine, MSHA does not have jurisdiction over it. Is even if it is doing 100% maintenance work on the mining equipment. Now, in the KC Transport case, this is not located on mine property, but it's kind of back and interconnected to multiple mines by haul roads. And back there, this company has a repair facility where they park their trucks before they dispatch to go out to a mine and haul material for the day. And this is coal in this instance. So, you know, an inspector went up there and issued citations on 2 of the trucks. The stance there was these trucks are used in the mining industry. They were on a mine earlier today, or they'll be on a mine tomorrow. We have jurisdiction over them. In the ALJ's decision, essentially the ALJ gave MSHA authority over the repair facility as well. You know, the determination was that, one, this was all interconnected to the mines, because it's on the haul roads that have access. It was all used for the mining industry, and therefore also be under MSHA's jurisdiction. That decision, when it went up on appeal to the commission came back down and said, no, we don't find that to be the case. They cited Maxim and some other cases that limited MSHA's jurisdiction, and they vacated the citation and granted KC Transport's motion for summary decision, vacating those. So, you know, it is still ongoing in litigation before the Court of Appeals for the DC Circuit. We will see what that decision comes out from, but this is a big decision in that it's going to let MSHA know how far they can go from the actual mine itself. You know, this is a question of pushing the boundaries of where MSHA can push to for contractors or for other offsite facilities. You know, the big question, and I don't think it's, you know, of any contest, but, you know, were these vehicles in service to the mining industry at the time of inspection or at the location where they were observed? And the determination by the commission is they were not, right? They were not carrying coal or other materials from one part of our mine to another at that time. Therefore, they were not performing services to the mining industry at that point in time. And they were also not on the mine property. So that is a big distinction here from what we're going to see in our next case that we're talking about, because, you know, it's not only what you're doing, but where you're doing it. And so, you know, we're going to watch this one closely, especially in the DC circuit, you know, strategically, when we take a case to litigation and then we can appeal it from an ALJ decision to the Federal Mine Safety and Health Review Commission. If we want to appeal the Federal Mine Safety and Health Review Commission, we can appeal it to the federal circuit court system for review. And when doing so, you can do it at the location where the company is, in whatever circuit that might apply to, or you can take it to the DC circuit because that's where MSHA is located. So in this case, MSHA is appealing the decision. They decided to take it to the DC circuit for review. I believe this took place in West Virginia at these facilities, so it would have been part of the Fourth Circuit if they did it where the mine was located. So that's kind of a strategic decision that we usually see parties have to make, and that we have to consider if we're appealing something beyond the commission. And that maximum rebuild case was from the Sixth Circuit. So it's not controlling necessarily, but will be persuasive to the circuit that is reviewing it. In this case, the DC Circuit, or if they had taken it to the Fourth. So some questions, about how this one comes out, but it's really about limiting where MSHA's footprint can go. And it seems though that this is just going to be something we continuously have to evaluate and litigate. A different case that also looks at where was a contractor and what were they doing is from a couple years ago, that it was finally the petition was denied. But it's important when we're talking about, KC Transport, they're a contractor, where could they be cited, where could they couldn't. In this case, the question is, did MSHA have jurisdiction to cite a contractor for not setting their parking brake in the mine parking lot when the contractor went to sign in at the mine office? And in that case, the company was there, they rented water pumps, the contractor was on site to service a water pump, and they appealed and said we weren't in the process of performing any services yet at the mine. I mean, I think, that is an interesting way to look at it, but you were on the mine site getting ready to perform those services. So I think that this is understandably a case where the ALJ and the commission both found that it was a contractor who was on site frequently, had been on site before to perform the same services. They were going to go down and perform those services. They just were checking in at the office. They were subject to MSHA jurisdiction, right? The other question that kind of came up here was, did the inspector violate the contractor's walk-around rights under Section 103F of the Mine Act by inspecting his truck when the contractor wasn't present? Because as it goes, is the inspector claimed that he saw the truck park, he saw it rock, which to him indicated that it did not have its parking brake set, and he went over and couldn't see that through the window, so he opened the door of the truck without the contractor employee being there. And so there was also a question asked of were the walk-around rights violated. Now, we should always enforce and utilize exercise our right to accompany MSHA during an inspection. In this case, though, it was found that it wasn't violated because really nothing would have changed had the miner been there, had the contract employee been there. Because if they would have opened up the truck door a minute later when the contractor was there or not, it wouldn't have changed the fact of whether or not this parking brake was set. And no mitigation that he had provided in that time frame would have really kind of switched that, whether or not it was set or not. So it was a bit of an interesting take there in terms of the 103F argument, and whether or not I think jurisdiction applied here in general. We understand, and we should understand, that if people are on our site, they are going to be subject to MSHA inspection, right? The question that often comes up with contractors is, are we required? What kind of training are they required to have? Are they required to have comprehensive miner training, or they're required not to have comprehensive miner training because they are not on site for frequent or extended periods of time, or they are not participating in active mining process? So, those are questions that we have to think about with contractors. And that's a discussion we'll have later this year during one of our webinars. But, two different instances where contractors were cited. One, the contractor was on site in the parking lot getting ready to head into the mine. I think probably if KC Transport, where that truck was cited about to be loaded, there would be no case, right? If it was on a mine about to be loaded. So the location is important, and the location has to be evaluated where things are taking place. In terms of that, with the 103F rights, yes, it's true that any employer or operator has the ability to accompany MSHA when they're inspecting their area, their operations, their equipment, and I think every company should exercise that right. If you're a contractor or you're working with contractors and they want to make sure they're exercising that right, you can try and coordinate with that beforehand about what you're doing and how you're going to contact them. You would be able to contact a contractor and let them know that MSHA is on site going to inspect their area. That is not necessarily advance notice unless we're broadcasting it to an entire large group of contractors. But if we have one designated individual who's going to accompany MSHA, obviously we're allowed to contact them so that they can exercise that right as well. Our last case we want to talk about here has to do with borrow pits. Borrow pits are a question that continues to come up, and we continue to find different ways to question whether or not an activity is a borrow pit or not. And a lot of it comes back to what is happening on that site. Are we engaged in milling? This is a recent case. The Sixth Circuit decision just came out in May, and issue was whether a source of material used during roadway construction project for fill material was a borrow pit or not, right? And a borrow pit would be subject to OSHA jurisdiction. If it is not a borrow pit, it's a mine subject to MSHA jurisdiction. The decision several times over was that it did constitute a mine and was engaged in mineral milling, and that they were not a borrow pit. So this case has a long procedural history, because at first it went up and it was decided, and in a unique procedural way, the respondent won by essentially asserting an argument, and the circuit court agreeing that the Federal Mine Safety and Health Review Commission's ALJs were not confirmed by the executive branch, and therefore were unable to make the decisions. They found that was correct. There was a procedural misstep, and then they came back and the commission repaired that and had the case heard again. In that second decision, the ALJ came to a similar conclusion that the borrow pit was a mine, that it was not a borrow pit. That decision was confirmed or affirmed by the commission, and then the Sixth Circuit did the same. So what do we look at when we're looking at a borrow pit? These are the questions that came down in the analysis in this distinction, in this case. So the questions that were being looked at was the extracted material, did it constitute overburden, right? It is extractions on a one-time basis or intermittent. The extracted material must not be milled beyond the use of a scalping stream, as we talked about. The extracted material must be used more for its bulk as fill than for its intrinsic quality. And the extraction site must be relatively near where the extracted minerals are used or materials. So in this case, what happened is Jones Brothers, they got a road construction project, and they were going to extract material nearby in order to provide the road base. The question came out about whether or not it was a mine or not when MSHA showed up and issued citations. Essentially, the background is the state of Tennessee gave them specifics or specifications for the material that could be used in this project for fill. They explored this area, they took core samples, they evaluated the material and determined it could be. In addition to that, they were also given size requirements that it had to meet in order to be used as fill. So the company extracted it through drilling and blasting, engaged in some sizing of it by breaking the material and crushing it on a limited extent, and then trucked it to their location for roughly 7 months, where it was used as the fill for the road. So what came down were a lot of different questions, right? So, was the material overburden? No, probably not if you had to drill and blast to remove it. Was the extraction on a one-time basis or an intermittent basis? The allegations for MSHA were that they were operating 6 days a week, 10 hours a day in order to extract and create the material that was used as fill. So, that may be a one-time basis in terms of for 1 7-month period, but it was being operated very consistently and in no way intermittent at that time, is essentially what was decided. It was being milled in terms of extraction and sizing beyond just using a scalping screen. And the argument was made that it was being used for its intrinsic qualities rather than just being bulk fill, because they had to have it tested and it had to meet certain criteria in order to be used for the road base. So essentially the court found that all of those applied, which would lean towards it being a mine site. It did satisfy the criteria that it was relatively near the location where the materials were going to be used, but that wasn't enough to pull it back into the borrow pit qualifications. So, it's an interesting case, but I think it bears looking at the fact, though, that, when we're talking about borrow pits, we're talking about very, very basic operations where we are simply extracting material, putting it in a truck, and it's being dumped out of that truck. Maybe we are scalping in order to get large rocks, wood, or trash out. But otherwise, we aren't processing. We aren't sizing. We aren't, evaluating the good material from the bad for one reason or another that's really in any way tied to a specific need for it. It has to be just kind of very basic pullback and extraction. So, those are questions, though, that continue to be asked. I work, with a client who was, being inspected by MSHA, and they didn't think they should be. And so we pushed back and our arguments were, we are a borrow pit. We aren't subject to MSHA's jurisdiction because we aren't operating on a regular basis. We aren't, doing any processing. We didn't even have a single conveyor or scalping screen present there. It was just very basic operations, but, the MSHA inspectors wanted to discuss, well, what is your effect on commerce? Well, any use of material in a business project is an effect on commerce. So we're going to, so we have to explain that's not material. And then they want to know, is there other alternatives in the area? Could this material be bought from someone else that's operating a mine? Again, that's not what this court is saying are determining qualifications. So if you're having these discussions with MSHA, we want to keep it tailored to what is taking place, not kind of external factors of, what else isn't available in the area? What else are we affecting commerce? We're going to be found to be affecting commerce. That's a very low bar. If we're extracting material and using it somewhere, it's going to be affecting commerce. So, a good case, though, that has a lengthy procedural history, because there was kind of different elements of the challenge where procedurally Jones Brothers won at first, but then on the merits of the case, it was decided again after that kind of procedural hiccup was remedied by the commission. So we've talked a good bit about deference here, and I'm going to cover this quickly because I don't want to get too far astray. But we've talked about deference. The agencies have deference to determine what is milling, what is manufacturing, where do those lines break? Well, we don't have specific, standards of where they do, right? We have some where milling, but we can see in Cranesville, there's drying taking place there, and they still said it was part of the manufacturing process. And a court agreed. And that is because of what's called Chevron deference. And that's a legal doctrine. It comes from a case from the Supreme Court, which SCOTUS, Supreme Court of the United States, in 1984, where Chevron versus Natural Resources Defense Council. What it essentially means in the most Cliff Notes way possible is that if a law is ambiguous or an interpretation is ambiguous, the courts and judges should defer to agency interpretation of the law as long as the interpretation is not unreasonable. The counter argument to this is that it gives the agencies the ability to expand their reach or kind of act inconsistently based upon their specific case. Again, I kind of go back to Cranesville on this when my thinking. And it's been used to, uphold a lot of rules or create kind of new obligations on existing rules because Congress did not specifically speak to every certain instance and possible occurrence when drafting documents like the Mine Act or the OSHA Act. This has kind of it's been used as a way to say, the law can't always state everything we need it to be clear, right? And if there is ambiguity, as long as an administrative body, an administrative agency's interpretation of that is reasonable, it is not unreasonable, we give them the deference to kind of go that route. And a lot of times in these jurisdiction cases, we are giving the agency deference to decide where milling occurred or manufacturing occurred or something along those lines, or what is the definition of milling. It's something that we need to watch out for, not just for jurisdiction cases, but for administrative law cases in general. There is a case that was taken up relatively recently, Loper Bright Enterprises, by the Supreme Court, and many people think and anticipate that the justices could issue a decision not just on that case, but also in a way which either upholds or overturns Chevron deference. So that's going to be a pretty influential case for us. It's going to be something that we're watching. The agencies are certainly watching it. The administration is watching it, because that will really be a departure in what is almost 40 years of doctrine, legal doctrine, and how cases have been decided. So do we know what's going to happen? We don't. But with the way the Supreme Court's made up and kind of the signaling, this is very much a case that could see Chevron deference overturned, depending on how the arguments go in the briefing and things like that, and where the decision comes from the justices. So an interesting case to be watching for. So what do we do with jurisdiction questions? One, don't wait for MSHA and OSHA to make the decision for you. Kind of look at it, be proactive in evaluating your operations, your contractors, what you see as gray areas, or the areas where you see MSHA maybe sniffing around or OSHA sniffing around, where they're keep asking to go over to a specific spot, and they just want to see it, they just want to check it out. Be careful there, and if you're having those kinds of doubts or those concerns or those occurrences take place, dig into that. As I mentioned before, and I apologize to the questions that came in, because it's hard to give a specific answer, and I'll reach out to those individuals to kind of discuss it further. But consult legal counsel as necessary. The jurisdictional arguments, a lot of times we're looking at case law to make those determinations and kind of guide us and evaluate that. So don't wait for them to make the decision for you. Look at your operations. Consider proactive discussions with MSHA or OSHA before we have a citation issued. If we want to challenge something, just give that example of a client who had an operation for a number of years. You know, we were getting ready to start a new operation, and we didn't think it should be under MSHA jurisdiction anymore. And so before we started that, you know, before we started that new operation, we had those discussions with MSHA, and in that process, before there was enforcement, before there were citations, we were able to have that discussion. We weren't under time frames. We were allowed to deal with the agency and get kind of a resolution, you know, without being intermixed in the contest and legal process at the same time. But finally, though, if enforcement is issued, contested immediately. Contested immediately on the grounds of jurisdiction. If you are in the MSHA or OSHA process, informally contest it, but informally contest it knowing that the record is still open in the MSHA context and that everything is going to be included in the file. So prepare yourself very well. I would encourage you to prepare yourself and, you know, partner with legal counsel in doing that informal, but just continue to pepper the record that this is a case of where you don't believe there's jurisdiction. So there's no question of whether or not you ever accepted it. And so that's, you know, that's it, everybody, on jurisdiction talk today. I appreciate you sticking around a couple of minutes extra as I went over. We'll have another webinar in a month, just looking at kind of some updates on cases beyond what we talked about today. And then we got a few more webinars scheduled out for the year, and particularly I'll point you all to the multi-employer worksite one, because if you have questions that have to come back to, you know, what training requirements are contractors having to have, I didn't get into that today. We'll talk about that in the November audit, but if you have questions before then, I'm sorry, November webinar, but if you have questions before then, you know, feel free to reach out to me, give me a call, shoot me an email, and we can talk through those. In terms of kind of updates as we go, as always, follow the Con Carry blogs for continued updates in any of the areas that apply to you. I'm happy to take more questions at this point in time. I will review what's already come in, but at this point, I think we're probably gonna just keep those. I'll reach out to the individuals and to talk about it a bit further, as the questions are gonna need me to get some more information from them. But if there's any more to come in, I welcome them, and thank you very much for your time. Have a great day and a good rest of your week, and appreciate you all hanging around today.